If you've been arrested for DWI in Texas, what you do before you ever step into a courtroom can matter just as much as what happens inside it. My name is Joseph Ruiz. I'm a criminal defense attorney here in Houston, Texas, and I focus almost exclusively on DWI cases. And here's something most people don't realize. By the time you go to court, a lot of damage or a lot of opportunity has already happened. I've represented people from all walks of life: nurses, oil and gas workers, parents, professionals, good people who made one mistake or got caught in a bad situation. And the cases that turn out best usually have one thing in common: the client took action early. So today I want to walk you through the 5 things you can do before court that can actually help your DWI case in Texas. Number 1, hire a Texas criminal defense attorney immediately. This is always step 1. Texas DWI is technical. Breath tests, blood tests, field sobriety tests, officer training. None of this is simple, and local courts matter. Harris County is not the same as Fort Bend, Montgomery, or Galveston. I've seen cases where the evidence looked solid at first glance until we dug deep into the details and found mistakes that changed everything. The earlier you hire a DWI attorney who understands Texas law and the science behind DWI testing, the more options you usually have. Number 2, request the ALR hearing within 15 days. This is huge and people miss it all the time. After a DWI arrest in Texas, you have 15 days to request what's called an administrative license revocation hearing, or ALR hearing. Miss that deadline and your license can automatically be suspended. But here's the opportunity most people don't know about. The ALR hearing lets us question the arresting officer under oath and preview the state's evidence early on. That alone can shape the entire defense strategy. Number 3, write everything down and gather evidence. Memory fades fast, especially after a stressful arrest. As soon as possible, write down why you believe you were stopped, where you were, what you ate, what you had to drink over what period of time, where you were coming from, how the officer spoke to you, what tests were given, which ones were not. Then, with your attorney, request body cam footage, dash cam video, and police reports. Many cases are won by comparing what actually happened on video versus what's in those reports. The details matter. Number 4, take proactive steps before court. Judges and prosecutors are human. They notice effort. Depending on your case, proactive steps may include alcohol education classes, community service, victim impact panel classes. This isn't admitting guilt. It's about showing responsibility and seriousness. I've seen proactive clients able to secure complete dismissals based on taking these proactive strategies. Number 5, stay clean and follow every bond condition. This one sounds obvious, but it's critical. A clean record while your case is pending tells the court that this was an isolated incident, not a pattern. Violating bond conditions, on the other hand, can destroy leverage fast. One last thing, and this matters: a DWI arrest does not mean you're automatically guilty. It does not mean that your case is hopeless, and it does not mean that the police version is the final word. Juries decide cases, not assumptions. If you or someone you care about is facing a DWI charge in Houston or anywhere in Texas, don't wait and don't guess. The steps you take right now can protect your license, your record, and your future. Call our office, schedule a consultation, and let's talk about your options before court while they still matter. I'm Joseph Ruiz. Thanks for watching and take care.